This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Now I get the pleasure of introducing Phyllis Cheng. Phyllis Cheng is a neutral at ADR Services where she mediates employment, wage and hour, civil rights, and other cases. She also serves on the mediation panels of the California Court of Appeal, 2nd Appellate District, and the U.S. District Court, Central District Court, District of California, where she runs its mediation practice group. Ms. Cheng was a director of the California Department of Fair Employment and Housing under Governors Arnold Schwarzenegger and Jerry Brown, as well as a member of the Fair Employment and Housing Commission, Comparable Worth Task Force, and Commission on the Status of Women. Ms. Cheng was a partner at global firm DLA Piper's Employment Law Group, of counsel at employment firm Littler Mendelsohn, and associate at civil rights firm Hadsel and Stormer. She also served as senior appellate court attorney at the 2nd District Court of Appeal and Deputy Attorney General at the California Department of Justice. She is a co-editor of California Fair Housing and Public Accommodations, the Rudder Group, managing editor of the California Labor and Employment Law Review, writer of the California Labor and Employment Case Law Alert, and contributor to California Employment Litigation and other publications. The State Bar named her the 2014 Ronald M. George Public Lawyer of the Year. Ms. Cheng received her BA, MED from UCLA, JD from Southwestern University School of Law, and PhD from USC, where she was a James Irvine Fellow. So Phyllis, passing it to you.
Thank you, Hayward, and welcome to this presentation. We're going to be covering a few topics related to recognition and the elimination of bias in your law practice. Specifically, I'm going to be introducing you to the Unruh Civil Rights Act, which definitely applies to all law offices. I'm going to talk about the California Rule of Professional Conduct, Rule 8.4.1, specific to lawyers, the obligation of law firms and attorneys under all of these provisions. We're going to talk about examples and hypotheticals, as well as best practices. So first, I want to say that every slide is going to have art by Sonia Delaunay, abstract art. All of this is in the public domain because the art was created prior to 1924, and also for persons with access issues. In addition to this art, we will also have the ADR Services logo on every single page. Now, the Unruh Civil Rights Act is really the primary civil rights act in the state of California, regulating businesses, including law firms. It specifically says that all persons within the jurisdiction of our state are free and equal, and no matter what their sex, race, color, religion, ancestry, national origin, disability, medical condition, genetic information, marital status, sexual orientation, citizenship, primary language, or immigration status, are entitled to the full and equal accommodations and advantages, facilities, privileges, or services in all business establishments of every kind whatsoever. Now, the Unruh Act was first enacted in 1959, but it had some early common law precedents. Early in California law, back in 1897, the legislature enacted common law doctrines into the statute, which are the predecessors of the Unruh Civil Rights Act. And these early statutes basically provided that all Californians would be given equal access to various types of facilities. a 1905 amendment added things like, certain types of establishments, also in 1919. In 1923, the legislature extended these provisions under Section 51 to places where they can congregate. So more and more early on, the legislature included definitions of what constituted a public accommodation. Finally, in 1959, the modern Unruh Civil Rights Act was enacted. And for the first time, it expanded Section 51 to prohibit public accommodations on enumerated bases of discrimination, some of which I've already read in the statute. Thereafter, the Unruh Act became and continues to be the robust civil rights law that it is today. And it now prohibits discrimination against all the bases we talked about. Now, what kinds of business establishments are covered? The Unruh Act protects all persons of discrimination by all business establishments, some of which may or may not even know they are business establishments, including law and mediation offices. But some of these establishments include hotels and motels, nonprofit organizations that have a business purpose, for example, even a club, restaurants, theaters, hospitals, barber and beauty shops, housing accommodations, public agencies, including our courts, retail establishments, other governmental entities, and of course, law offices. Important to California attorneys who practice, say, in the employment arena, the California Supreme Court had expressed early on that employment discrimination claims are excluded from the Unruh Act's protection, primarily because both the Unruh Act and the Fair Employment Practices Act, which is the predecessor act to the Fair Employment and Housing Act, were enacted at the same year, 1959. So let's take a look at what are some of the elements of an Unruh Act violation. An Unruh Act plaintiff has to establish the elements that are posted here on the slide, that they were somehow denied or aided or incited or discriminated against because of the prohibited bases in the accommodations or advantages or facilities or privileges of services provided to them. They also have to prove that a substantial motivating factor for the conduct was because of the defendants, the business's perception of plaintiff's protected bases under the Unruh Act, or maybe they're associated with somebody who has one of those bases. Another element is that plaintiff has to have been harmed. And finally, that the defendant's conduct was a substantial factor in causing plaintiff's harm.
Phyllis, sorry to interrupt. I think you might have minimized your PowerPoint slide. Can you share your screen one more time, please? You'll have to reshare your screen.
All right, so apologies for that glitch. What are some of the Unruh Act types of remedies available? They include statutory damages, out-of-pocket expenses, cease and desist orders, and this also includes any types of claims under the ADA, but of course the Unruh Act is broader than just disability discrimination. It includes damages for emotional distress, punitive damages, attorney's fees, and costs, court-ordered damages, which can also include treble damages. So this is a powerful law that impacts so many business establishments in a very significant way. So what are some of the affirmative defenses that the defendant can have in if somebody were to file a claim against them? Well, undue burden is one. What is an example of undue burden? That could be something like, this is beyond the purpose of the business. It's a business expense that makes it impossible for the business owner to carry on the business. It needs to be a readily achievable kind of remedy. And of course, there are also First Amendment issues. For example, if, say, a baker does not has a religious belief to only provide or make wedding cakes, for example, for people of the same sex marriages. That is still being litigated in the courts, but that's certainly a First Amendment kind of a defense. There are also construction defect defenses that are particularly pertinent to disability access types of violations. Statutory damages, out-of-pocket expenses, emotional distress, punitive damages, and all such things means that and a business owner, including lawyers and law firms, can be open to such damages. So having these affirmative defenses are an important type of remedy. Now, the California Rules of Professional Conduct, Rule 8.4.1, is something that is particularly specific to attorneys and law firms. This is a rule that changed former rule of the professional conduct under the old state bar rules. Formerly, the state bar rules provided that in order to find an attorney or a law firm liable for any kind of discrimination conduct, especially against a client, that a tribunal had to have first prove that or rule that the attorney had violated those state bar rules. But several years ago, the Council on Access and Fairness, of which I was a member, recommended changes to Rule 8.4.1 such that in representing a client or in terminating or refusing to accept the representation of a client, that the state bar actually can conduct its own investigation and have its own hearings prior to any other type of tribunal ruling on these provisions. In addition, the state bar rules and current state bar rules 8.4.1 prohibits discrimination, harassment, and retaliation in representing a client or terminating or refusing to accept the representation of any client along the same lines as the bases prohibited by the Fair Employment and Housing Act and the Unruh Civil Rights Act. It means such bases as race, religious creed, color, national origin, ancestry, physical disability, mental disability, medical condition, genetic information, marital status, sex, gender, gender identity, gender expression, sexual orientation, age, military and veteran status, and other categories of discrimination. Now, it also prohibits a law firm from treating its own employees in violation of these provisions. A lawyer who's the subject of a state bar investigation for violating Rule 8.4.1 upon issuing a notice of disciplinary charge under this rule, a lawyer must also provide a copy of this notice to the California Department of Fair Employment and Housing and the U.S. Department of Justice Coordination and Review Section. If the notice is of a disciplinary charge under this rule, the attorney must also provide a copy of the notice to the same bodies as well as to the U.S. Equal Opportunity Commission. It, however, does not prohibit a lawyer from representing a client or to have engaged in unlawful discrimination, harassment, or retaliation because of reasons permitted under the Rule 1.16, as well as providing advice or engaging in an advocacy as required or prohibited by those rules. But essentially, now in addition to the Fair Employment and Housing Act, the Unruh Civil Rights Act, the California Rules of Professional Conduct additionally require law firms to comply. So let's take a look at some examples of prohibited discrimination. Here's an example of race discrimination. A bank refuses to allow an African-American investment advisor to accompany his client who have accounts at the bank. Now, even though the African-American investment advisor is not himself a member or a depositor or user of the bank's services, because he is accompanying clients to the bank, this was a case that ruled, yes, the Unruh Civil Rights Act applied and the bank was liable. Another example is sexual orientation and marital status discrimination. Here, a lesbian couple, this is prior to passage of the law allowing same-sex marriages. In any event, this lesbian couple registered as domestic partners under the Domestic Partner Act. The country club they applied to refused to extend to them certain benefits that it extended to married members of the club, such as golfing privileges. And in this case, it was found that the Unruh Civil Rights Act applied, and there was, in addition to sexual orientation discrimination, this was also a form of marital status discrimination. Here's another example of transgender and associational discrimination. The mother of a deceased transgender son who had been a patient at the hospital brought an action regarding the hospital's alleged gender discrimination against her son. And even though she herself was not a patient of the hospital, she was deemed to have standing to bring an Unruh action on behalf of her transgender son. And here's another example. An administrator of law school admissions tests, which is the LSAT, violated the Unruh Act by failing to reasonably accommodate test takers with disabilities and flagging their scores. This was a case that was settled at the national level when I was director of the Department of Fair Employment and Housing. And here, the law school admissions test, many times people with disabilities would ask to have an accommodation under this test. And many times they were refused the accommodation. And whenever they were accommodated, the council would flag the scores of these individuals and let every single law school know that these individuals didn't take the LSAT test under testing conditions. This case settled for almost $9 million. So this is an example of how educational institutions and even testing entities can be put under the Unruh Act scope. Here's another example of associational discrimination and arbitrary discrimination. Now, under the Unruh Act, unlike many other types of statutes, there's been a court-created category of discrimination called arbitrary discrimination. The California Supreme Court and other courts have held that the Unruh Act was designed to prohibit discrimination in a very broad and liberal manner. So arbitrary discrimination, or if you want to call it implicit bias, is also covered under the Unruh Act. So somebody with here, a business cannot, under the Unruh Act, arbitrarily exclude a customer just based on his association with a friend who had long hair and was dressed in an unconventional manner. So even if this is a category that is not enumerated under the law, so long as it's arbitrary, it is also covered under the Unruh Act. A prime example is that most of the time when we hear about age discrimination under the, for example, the Fair Employment and Housing Act, the Title VII, the Age Discrimination Employment Act, it has to do with people over the age of 40 or above. There are really no enumerated categories there regarding people who are younger. However, under the Unruh Act, it would be possible under the arbitrary discrimination category to include individuals who are not enumerated. So young people could be part of that. Family members, families with young children can be included in that. People who look different, have long hair, maybe have, hairdos, or wear clothes that are not conventional, they would also be included. So take a look at now some of our hypotheticals given all of this. Your law firm sponsors an online seminar for business development in the Shanghai market. The firm directs its invitation directly to attorneys of Chinese ancestry. Is this a violation of the Unruh Act? Well, it probably is, because while the law firm wants to develop the Shanghai market, it assumes here that only people of Chinese ancestry practicing in California would be eligible to develop that market. In fact, there are many non-Chinese attorneys who may actually be quite capable of doing this work, and it would be a kind of national origin ancestry discrimination, and perhaps also arbitrary in limiting this kind of business to only Chinese attorneys. Here's another hypothetical. You schedule an intake interview of a potential new client for your law practice. The client is deaf and asks for an American Sign Language interpreter. Do you have to comply with this request under the Unruh Act? Well, generally, you would have to do that or provide some kind of an accommodation. So for example, if there are less expensive types of accommodations that can do the same thing to allow access, you don't necessarily have to have an American Sign Language interpreter. You can actually have other lesser forms. For example, many people with hearing disabilities or visual disabilities will have other types of accommodations already installed in their, wherever they are. So if you can do it by telephone, so that there's, a relay system, that is also possible. Today, Google has a way of transcribing language as they're spoken. Even Zoom has a vision like that. May not be perfect. It does not have to be the best kind of accommodation, so long as it's an accommodation. But definitely, just like in the employment context, having some kind of interactive process with that potential client to find out what can work for that client, the needs, what the client needs and what you can provide, that would be an important step in assuring that your law firm complies. Here's another hypothetical. Your law firm is in a high crime area with gang activity. Your client brings her teenage son to a meeting with you. He's wearing the colors of one of the rival gangs. The building management doesn't let the son into the building. Is there an Unruh Act violation? Well, maybe. First of all, your client brings the son. Is the son actually necessary? Is the son a client using your business? Now, even if not, are there other things that can be done? For example, can the son not wear those colors, take off a jacket or something like that, so that it does not become a threat to the business? The other thing is, this is the building management that does not let the son into the building. There is joint and several liability between a business tenant, the law firm, and the building management. So there are, issues. This is certainly not one of those clear-cut cases. It also is an arbitrary discrimination issue because of the colors that the teenage son is wearing. Not so much because the fact that this is a teenager, but these are issues that should be hashed out and thought about before you eject a person like this from your business. Here's another hypothetical. Your law firm hires an outside trainer to provide training to your staff. The trainer makes explicitly racial remarks to an African-American staff member. Your staff member complains of race discrimination. Is this actionable under the Unruh Act? Well, there is actually a recent case that the Court of Appeal has issued. No, it's the Supreme Court that has issued, and that has to do with this exact case in which a contractor went into a Jiffy Lube establishment for staff training and said a bunch of racist things to a staff member. And this case is called Smith v. BP Lubricants USA. It's a 2021 case, 64 Calap 5th 138, in which the court held that the employee possibly alleged the trainer, was acting as a business establishment in the employment arena. So even though our Supreme Court has specifically said that the Unruh Act does not apply to employment, there can be a kind of a mixed context in which the Unruh Act can be applied. Here's another hypothetical. You schedule a deposition in your office. The deponent uses a wheelchair, complains parking lot lacks signage and disability parking. Are there Unruh violations? Yes, there are, because this would be a violation of the Americans with Disabilities Act, and a violation of the ADA is a violation of the Unruh Act. What are the potential monetary risks? Well, there are, some of the statutory issues we talked about, and most of the time, plaintiffs will file both an ADA and an Unruh Act violation. So this means they can get attorney's fees and costs and so forth. Who is liable? Well, this would be both the landlord of the building as well as a law firm can be liable. Here's another hypothetical. Your firm's third-party electronic payments processor requires users to certify they wouldn't accept payments in connection with bankruptcy attorneys or collection agencies engaged in the collection of debt. Is there an Unruh Act violation? Well, actually, there is. There's a recent opinion by the California Supreme Court, I believe, in, I'll find the case for you. It's in my law review article that I have attached. And this case is called White v. Square, 2019, 7 Cal 5th 1019. And in this case, it had to do with a collection service which refused to have any business with bankruptcy attorneys, and this was found to be a violation of the Unruh Act as well. So it's a form of arbitrary discrimination that we have to watch out for. So best practices. What should you do? You should develop policies and practices to ensure compliance with the rules of professional conduct we talked about, 8.4.1. You should conduct regular training for all your supervisors and employees. Ensure that your leases include indemnification clause, because again, the premises, if there's any kind of premises liability, there's a joint and several liability between the business and the commercial landlord. Be aware of all office operations. Make sure that your staff realizes is conversant with all of these rules from intake all the way to the end of a case. Develop a complaint procedure internally for your own staff, and then adopt a protocol for investigating and resolving complaints. So thank you so much for attending this portion of our MCLE Day. Here's my contact information. I welcome any questions from you. Thank you so much.
Hi, Phyllis. Okay, perfect. I have some questions for you that I'd like to read off, and then perhaps you can give us your feedback. Is a website a public is a website a public accommodation?
Yes, it is. A website is absolutely a public accommodation. And it is so under the ADA, and it is already deemed so in the White case that I talked about.
Okay. Here is another one. I have not seen the attorney's fee provision in the Unruh Act. Is that court ordered or actually in the Act? As again, I have not read that in the provision.
It's in the Act as well as court ordered. Most of the time it is a court ordered attorney's fees. I mean, it depends on what your fees are, but it is specifically provided for in the Act.
Okay, perfect. I think this is a question. So the question asks, what about vaccination status?
That's an interesting question. That would certainly fall under the arbitrary discrimination portion of the Unruh, expanded liberal interpretation. We haven't seen any cases like that, but I imagine that in the age of COVID and vaccinations, that we are going to be seeing this, and it would be, I think, a very viable area under the Unruh Act.
Next question I have for you is, what about firing from not allowing a religious exemption for refusing vaccination?
That also would be provided and protected by the Unruh Act. On the one hand, you have the business establishment's concerns about, accommodating people's religious beliefs. On the other hand, you also have you have to balance that with their concerns about operating a business that is safe for all consumers. So these are, under the COVID era, we have so many new types of arbitrary discrimination that are still there to be flushed out.
All right. And this question is from a civil rights lawyer with the focus practice on FIHA disability cases. Can you comment on the use of Unruh by out-of-state plaintiffs who are targeting small businesses via website access claims? He further comments saying that there appears to be a cottage industry around these claims, and these claims seem to be a part of a pernicious trend to exploit the law's intentions.
I guess it's a very long question.
So let me read that.
And it would be, if it's all right with the questioner, if you could email or send that to Hayward, I would be happy to provide my answer in writing to you and cite any authorities that I can provide you with. Thank you.
Okay, perfect. Just to let you know, you can either email me at mcilly@adrservices.com, or you can email me directly to me at Hayward, that's spelled HAWARD @adrservices.com. Have you found an increase in the past few years in an uptick in bias claims?
I think that bias claims are probably pretty constant over time. And when I was DFVH director, I found that, and we received, Unruh Act complaints, FIHA complaints, Ralph Act complaints. I found that the claims were pretty consistent over time. Even after, for example, the Me Too movement, the percentage of, for example, sexual harassment claims were pretty constant. in the state of California, about 7% of all claims received by DFEH. And at the EEOC, for example, it's about 14%. But the strange thing is after Me Too, maybe because of all the training and maybe there might be settlements outside of court that we don't know about, the number of claims, the percentage of claims actually went down at the state from 7 to 6% and at the federal level from 14 to 13%. And I think that, you know, these laws have been pretty mature over time. The Unruh Act and the FEHA are more than 60 years old now. And over time, we have seen a growth in certain areas, but they have stabilized. And I would still say that the largest area of discrimination continues to be disability discrimination. That's continuing to be a large percentage of all claims filed and continues to perhaps grow a little bit.
Okay. The next question that I have for you, Phyllis, and thank you for answering all these questions for us. When employers provide for unpaid leave in response to a request for a religious exemption to a vaccine requirement, is that de facto termination?
I think that the courts are going to have to come out with some decisions about what that means. And of course, it's also a case specific kind of determination. I had, at the beginning of COVID, I had mediated and settled the case in which an individual actually didn't claim to have a disability, but had an underlying medical condition of diabetes. And her employer put her on leave just because they were afraid that she could come down with COVID if she had been exposed, since it was, you know, they had customers coming in and out. And I think in a case like that, it certainly was a perceived disability discrimination because there was no disability. Nobody asked for an accommodation. In some other cases that I have mediated and settled, it might have a slightly different outcome. So I think it really is a case-by-case determination. And until we have further clarification from the courts, it's really difficult to say one way or another without looking at the case.
Got it. I have one more question to ask. Let me see. It says, I would appreciate receiving the information about the attorney sending demands for $4,000 for allegedly inaccessible websites. Is that something that you can elaborate on, Phyllis?
Are you talking about the case that if you're talking about the White case, I can certainly send you that information if you let Hayward know where you want to receive it. It's also in the law review article that accompanies this training, and you can find that citation there as well.
Okay. Sorry, Phyllis, I lied to you. We've got a couple more questions coming along the way. So this question says, a client recently had an accessibility claim based on the accessibility of Instagram feed for the client's business. Instagram subscribers have very limited control over the format of social media pages. I don't think there's any law in this area, but do you feel a business would be liable?
Instagram, you know, all of those social media platforms in which you just hold an account, it is really difficult to control what comes in and what goes out, who posts, who comments, whether or not you can remove anything on those platforms. It is a very, very difficult area and an evolving area of the law. I think that on your own account, if you have an account and you post something on there that is discriminatory, then I think the liability is clearer. But if it's because of other people posting or adding or responding, it's really difficult to control. I recently mediated a case regarding Instagram, Twitter, and other types of feeds that created, defamatory types of statements. And it was a very, very difficult kind of determination. I think that the law is a little bit behind our technology. And we're going to have to wait to see some clarification. But I agree with you that it's a very, very fine line. Also, there's also First Amendment defenses under, these platforms. So it's not an easy answer, and it is also a case-by-case determination.
Okay. On to the next. If an employer discloses an employee's COVID status to outside parties, is that something that is actionable?
That is an absolute violation. It's provided in the slew of recent COVID laws that have been enacted. The employers still must abide by, HIPAA regulations, privacy regulations regarding employees, private health information, that you cannot disclose it to outsiders.
Now that we have a bit more time left, Phyllis, is there any mediations that you've handled recently, or if just from your experience that you can share and kind of give personal anecdote to, that is more applicable to what you discussed today?
If you're talking about the Unruh Act, there are, of course, many cases regarding disability access. But even in other areas, for example, there was a case that I worked on that had to do with a homeowner who was a part of an HOA, Homeowners Association, and she had a hearing disability. She wanted to, talk about an issue regarding the homeowners board, and she went to the board and asked for a sign language interpreter. And the board just said, well, we don't have that. You're going to have to bring your own interpreter. So there was a case filed, and I successfully mediated that case. And in doing so, and this was a U.S. District Court case. So for cases involving the U.S. District Court, there are special types of resources available. So in that case, we had a sign language interpreter paid for by the courts for the plaintiff, who was the homeowner. We had, and she needed sign language interpretation. Her attorney had hearing disability, but did not need a sign language interpreter, but needed a different kind of service, kind of a instant, relay and information typing basically what was said. And we had both of those accommodations going on during the course of the mediation. And I have to say that the U.S. District Court providing those services really created a lot of goodwill between the parties, and a more complicated result that could have happened actually ended up being a very amicable settlement in which everybody got the services they need, and there was a resolution that worked for everybody. So that was one example.
Perfect. Do employers have a duty to inform employees if another employee is not vaccinated?
Employers have, under all of the recent COVID legislation, and I'm sorry, I'm not prepared to pull up the exact portion of the code, but an employer has a duty to inform employees if there's another employee or somebody's been exposed to COVID. Then there is a responsibility and a requirement for the employer to tell employees that, somebody's been exposed, and insufficient time for the employees who might have been exposed to take time off. And they also have to report that to health authorities. But they don't have to, and they should not talk about who was the employee who had COVID, who was the employee who caused the exposure.
Okay, perfect. So we still have a bit more time, Phyllis. Is there anything else you'd like to share before we reconvene for our next program?
I can tell you about some cases that are a case that's pending before the California Supreme Court. One of the cases is called Brennan v. Superior Court. It's the court below is the citation is 57 Calap 5th 367, and it's a petition for review And the question is a public school district a business establishment within the meaning of the Unruh Civil Rights Act? And even if a public school district isn't a business establishment under the Act, can it nevertheless be sued under the Act when the alleged discriminatory conduct is actionable under the ADA? So I believe that, I hope that the California Supreme Court will interpret the Act to cover school districts. In a 1993 decision of the former Fair Employment and Housing Commission, of which I was a member, we issued a decision called DFEH v. UC Berkeley, and it had to do with a professor, graduate student sexual harassment case. The citation is 1993 Westlaw 726830. And in that case, the former Fair Employment and Housing Commission determined that the commission had jurisdiction under the Unruh Act to rule on the professor graduate student sexual harassment. So, and there have been a couple of US District Court cases that have also interpreted the Unruh Act to apply to educational institutions, that they are business establishments. So I think that you're going to likely see a California Supreme Court decision definitively interpreting school districts to be business establishments under the Act. So that's something that is coming up. Also, there are more and more cases regarding websites as places of public accommodations and businesses. In addition to the White v. Square case, there's been another case recently called Thurston v. Midvale Corporation, 2019-39, Cal. 5th, 634, in which a blind user of a restaurant's website brought an action against the owner, alleging that its website was inaccessible to the user with screen reader software in violation of the Unruh Act. And Division 8 of the Second District Court of Appeal held that the plaintiff had standing to obtain an injunction. So this is, we are seeing more and more website access cases, particularly again during the age of COVID, when everyone is using their internet services for all types of services. So I think we're going to be seeing more and more of the website access issues under the Unruh Act as well. There's also been talk by the Council on Access and Fairness to recommend increasing the elimination of bias hours from 1 to 2 hours, and specifically establishing a subtopic on implicit bias, which is kind of a prerequisite or the underlying reasons for explicit bias under the Unruh and other types of provisions. So that's there is more and more focus on regulation of attorneys and their practices by the state bar. So those are some of the things that I'm seeing on the horizon. Any other questions that we can answer?
That just came in last minute. So I think this goes back to the case that you were sharing with us before. It says, the question reads, did you think that the HOA was responsible under the law to provide an ASL interpreter at the board meeting?
The HOA was, as a business, it had to engage in an interactive process with the homeowner to find out what would work for the homeowner, to ensure that she had equal access to attend the meeting and to express her views on an item that is of interest to her as a homeowner. Specifically, the HOA did not have a necessarily a responsibility to provide a sign language interpreter. I had actually asked the plaintiff what would have worked instead of a sign language interpreter. She said, well, it wouldn't be quite as good, but she could have used a telephone hookup, because there she would have a relay service, and that would allow her to both have information from the meeting and be able to interpret her questions and her responses to the discussion at hand. So it does not have to be the most expensive kind of accommodation, but in that case, a homeowners association just simply did not engage in the interactive process and just said, no, we don't do that. You have to bring your own interpreter. So I think that was the underlying issue. Had the HOA engaged in that and found another way, that perhaps a less expensive way to provide the same kind of accommodation, it would have worked.
Okay, perfect. And again, another question about employers and the most relevant topic of COVID. Should employers tell which employee was exposed to COVID to trace and make sure others who were near or exposed to that employee to get tested and quarantined as needed?
Well, so long as the employer does not disclose who is the employee who caused the exposure. Certainly, finding out who was there on the day that the person with COVID was present at the workplace, that would be important, but not disclosing. Very, very important to keep the HIPAA protections for all employees. The issue is to protect the workplace and protect all employees, including their privacy. But the last thing any employer want, or the last thing the policymakers would want, is for anybody to be ostracized because they were exposed to or had AIDS, or not AIDS, sorry, COVID, or any other communicable diseases. The privacy of the employee is very critical, as well as the safety of the workplace.
Oh, the questions are trickling in, Phyllis. Let's see. Can you please clarify, are you saying that there is a current litigation regarding websites providing reasonable accommodations to, i.e. like blind users? And I think to kind of add on to this question, another attendee asks, just for clarification purposes, any business that has a website, do they need to make it disability accessible?
Yes, all websites should be made accessible. And there are, there are providers out there who can go through your website to make sure that it's accessible. Remember that people who are not able to view the website, they cannot see things like PDFs, for example. It just comes out as a blank page. To ensure that your website is accessible is the first, really an important line protection for any business. So it's worth spending the money to get that done.
Perfect. Let's go over 2 more questions. So does the court asking you to bring your own interpreter violate the acts?
Courts, at least trial courts, are supposed to have interpreters. Appellate courts, not so much, because you're not going to have the plaintiff speaking to the court. You're going to have attorneys speaking, but of course, attorneys themselves can have disabilities. So again, I don't know that an appellate court has the resources to provide interpreters, but they certainly, courts and trial courts in general, do provide interpreters.
Okay, and I think I have time for one more question. I don't know if this is a trick question, but perhaps you can answer this for us, Phyllis. Is our Zoom presentation subject to visual access rules?
All websites and anything that's provided over the web is subject to these rules.
Well, with that being said, everybody, thank you for joining us today. Thank you, Phyllis, for that wonderful presentation.